Welcome to our Curious Amalgam, the weekly podcast brought to you by the Antitrust Law section of the American Bar Association. Our Curious Amalgam explores the fascinating and increasingly overlapping world of competition, consumer protection, data protection, and privacy law. Each week, we bring you leading global experts on the most compelling issues of the day. Enjoy the show.
Hi, and welcome to our Curious Amalgam, the podcast from the American Bar Association Antitrust Law section. My name is John Roberti, and today's program is Should Congress Enact Federal Data Privacy Legislation? The case for a national consumer data protection and enforcement regime. The protection of individual rights to privacy continues to build in importance as online businesses and social media continue to be key parts of our lives. There are data privacy regulations, but they are governed by different jurisdictions. The General Data Protection Regulation, or GDPR, in Europe is one example. California has its own regime, and there are also several other states that have adopted regimes. You might remember we talked about this in our third episode on our Curious Amalgam. That's more than 2 years ago now. And today we're going to talk about these issues again. We're going to consider whether it's time for national, federal, U.S. data privacy law. We'll be joined by Maureen Alhausen, the former acting chairman of the FTC, and we're going to discuss about whether comprehensive federal data privacy legislation is a better approach to regulating the collection, use, and sharing of consumers' personal digital data. My co-host today is Alicia Downey. Hi, Alicia.
Hi, John.
Alicia, what are we doing today?
Today, our special guest is Maureen Alhausen, who chairs the antitrust group at the law firm of Baker Botts, LLP. Maureen was first appointed as a commissioner of the Federal Trade Commission in 2012 and subsequently served as acting chairman from January 2017 to May 2018. Before serving as a commissioner, however, Maureen led the FTC's Internet Access Task Force. Maureen's published dozens of articles on antitrust, privacy, FTC litigation, and telecommunications law issues, and she's testified over a dozen times before Congress, most recently about the very topic of the day, consumer data privacy legislation, before the Senate Committee on Commerce, Science, and Transportation. Welcome to the show, Maureen.
Thanks so much. I'm delighted to be here.
Before we start, I just want to alert listeners that the webpage for this episode will have links to a variety of materials that are relevant to the topic, including a press release from the Senate Committee on Commerce, Science, and Transportation, talking about sort of the status of the federal legislation in play as of July 2021, Maureen's own written testimony from late September 2021, as well as an article that she wrote with two co-authors published in the section of antitrust laws, Antitrust Source. So there's a lot of good information out there in addition to what we'll be talking about today. What I want to do is just basically start, for those of us who have not been following this topic very closely, in broad terms, what kind of behavior is regulated by data privacy legislation?
Well, data privacy, what would be regulated is the collection, use, sharing, and protection of personally identifiable or reasonably linkable to an individual consumer data. Right now, we have sector-specific privacy laws. We have HIPAA for health information. We have Gramm-Leach-Bliley for financial information. We have provisions for communications information, but everything else is overseen by the Federal Trade Commission using its unfair and deceptive acts or practices authority. And the FTC has brought hundreds of actions for against companies for making deceptive statements about how the information is used or collected or shared or safeguarded, and also brought cases for data security violations based on its unfairness authority, which looks at whether there is an act or practice that causes or is likely to cause a substantial injury to consumers that the consumer can't avoid, and that's not, and then on balance, isn't beneficial to competition or to consumers overall. So that's kind of the lay of the land right now for the federal protection of individual information.
Okay, and I think John mentioned there are European regulations and regulations in different state jurisdictions. Is that correct?
That's right. So Europe passed a general data privacy regulation called GDPR that provides certain rights and protections to European consumers. And U.S. companies who are getting the data of European citizens have to comply with that. We are also seeing a number of states who are enacting privacy laws. There's California, Virginia, Colorado, and then there's some other very specific ones, like Illinois has one about biometric information privacy. So we're starting to see kind of a proliferation of privacy protections, which really very much complicates the landscape, both for businesses who are operating, outside of their state and possibly outside of the U.S., and for consumers too, to understand, well, what does this mean? What rights do I have? How does data cross state lines? Right? It's an intangible thing. What does that mean?
What's the earliest point at which federal data privacy legislation sort of became an idea?
Well, there have been a lot of discussions about federal privacy legislation really going back to more than a decade ago. And the question has been, well, should it be data security legislation? The FTC, while I was there, endorsed federal data security legislation. Should it also include privacy? So there's been a long discussion about at what point does that make sense? And, the Obama administration had a proposal, but I think that there's just been this increasing understanding. We already mentioned kind of the proliferation of various privacy regimes. I think there's been other developments in technologies. Certainly the development of the smartphone has now, and Internet of Things, a lot more connected devices. I think that's been raising some of the concerns that, maybe we need a federal privacy law. And when you think about, in the past more than a year now with the pandemic, that also has supercharged the debate, because we are all, kind of operating remotely and not in person. And sometimes there's been this rapid shift to online work and learning, and then deployment of efforts to track the path of the virus. All important privacy issues that come to the fore with those developments.
And what are the current proposals on the table right now?
Well, there are several bills before the Senate Commerce Committee that have been proposed. There's a lot of common ground in them. They give consumers strong privacy rights, provide them transparency, gives them more control over their data, robust security obligations, and some strong accountability for companies that collect, use, and share consumer information. And some of the other issues are, rights of access, rights of correction, the ability to give consumers portability for some of their data. Those are things that we're seeing in privacy, a number of privacy proposals. Kind of the two issues that are we don't see agreement across have to do with whether there should be a private right of action and whether a federal law would preempt state laws.
And what's your view on preemption?
So I think you need to look at these two things together, private right of action and preemption, actually, because, any bill, any legislation is, there's balancing that goes in. So turning to the preemption to begin with, one of the issues is consistency, right? for both businesses who are trying to implement these obligations and for consumers to understand. So if we end up with a federal law that's just the 51st privacy law, you don't get that consistency. And that regulatory complexity is particularly difficult for smaller companies or for startups or ones who don't have a big legal staff or can't hire high-priced legal counsel to try to navigate through this thicket of 51 and then you put GDPR on top, different obligations, privacy obligations. So that's I think an important reason to have a single federal law that would preempt the state laws. And also for consumers.
Yeah. And you're talking the complete preemption of the field, right? That would be
I don't want to really get into the details of that because I think that there's some complexities there. But when I look at a law that's worked, I think pretty well, is the Children's Online Privacy Protection Act. That is a single standard. The FTC applies it. The state AGs can enforce it to the FTC standard. And I think that approach has worked quite well. And then on the private right of action, one of the challenges there is we've seen other laws that have a private right of action just really devolve into something that's not directed at making consumers whole, that's not helping consumers. It's become sort of a vehicle for class action suits that where the attorney's fees are driving everything, and it's not really giving redress to consumers, and it's burdensome to companies.
On the preemption point, essentially in the absence of the federal law, companies probably have to go to comply with the most restrictive state law. I suppose that the federal law would give a clear standard for folks to aim at, but would the cost of that being maybe giving up some of the protections, or do you think the federal law would be as comprehensive as the most comprehensive state law?
Well, I think that's why we need to start with a strong federal law, right? That has strong protections for consumers and that's well-resourced for enforcers. And John, I wouldn't necessarily agree that, there's just one most strict standard that rules them all and you can comply with that and you're okay everywhere else. Because we certainly haven't seen that in breach notification requirements. In some states you have to do it in 7 days, in some states you can't do it in that time period. You might have to notify local law enforcement first and you have to wait. And so there could also be real challenges about what kind of data is covered in some states and not in other states. So I'm not confident that we would end up with a system where it's just comply to the highest standard, because there may be very diverse standards. And
it sounds like inconsistencies, at least as to data breach reporting, that would make
that's what we've seen.
Yeah, and just on the private right of action, something that comes to mind there is if you have the states and the feds with enough resources to enforce, you get a long way there. But with the FTC losing its authority to be able to get restitution and other civil damages, does that create more of a need for a private right of action? Is that the way to get money back in the pockets of consumers?
I don't think so, because one of the challenges is, and the FTC has many times said this, privacy violations, it's very hard to calculate what the harm is to consumers. So the redress or something. So I think what we've been advocating for, or I've been advocating for, is a federal law that has civil penalties for certain violations, right? So that the FTC could go after companies for these violations, and they put the incentives in the right place for them to put in place those protections and follow them.
You've been in front of various congressional committees talking about these issues for how many years now?
As a commissioner, several years, and then I've testified in 2019, twice in 2020, and so far once in 2021.
Until federal legislation is passed, or even if it's never passed, could FTC rulemaking perhaps substitute and provide at least some guidance?
So there is some interest in FTC rulemaking. And I'll talk a little bit about the limits of that. But just sort of as an overarching issue, when I testified recently, David Vladeck, former head of the Bureau of Consumer Protection, very consumer-oriented career, he and I both agreed that rulemaking is not like a substitute for federal legislation, right? And so my concern is kind of saying, oh, well, we can turn our attention and our energies away from federal legislation because we get most of what the agency needs through rulemaking. And I just don't think don't think that's right. So the FTC does have unfair and deceptive acts or practices rulemaking authority. It can essentially, through rulemaking, give particular examples of what it would consider an unfair or deceptive act or practice under the FTC Act. It cannot go beyond unfair and deceptive acts or practices. So there's a definition of unfairness in the statute. There is a deception policy statement, which has been taken up into case law. So some of the, so obviously, a company makes a promise, it's got to keep that promise, right? That's clear deception. We talked about some data security issues. But there are other parts that are well supported across the board in a federal bill that I don't think you could fairly say are an unfair or deceptive act or practice if a company doesn't offer them or do them. So think about access to data, access to your own data, or portability of that data, or the right to correct that data. I think it would be very difficult for the FTC to say it's an unfair or deceptive act or practice for a company not to offer those things. So you think about in the credit reporting area, I think it's underappreciated sometimes how the Fair Credit Reporting Act, when it was enacted, I think in 1970, it addressed many of the same kinds of concerns that we're seeing now. About there's a big database and it's got information again about me, and how will it be used, and what if there's an error, and those kinds of concerns. And Congress passed the Fair Credit Reporting Act that gave consumers these rights to access correction, to know okay, this data was used in a way that impacted an important decision, right, regarding my access to credit or housing or insurance, kind of a real, important sorts of services. And it struck this balance between the benefits of having accurate credit data for the whole economy and for people of good credit, and the downsides for people who have bad credit, who have not paid their bills, who maybe don't want others to know that. But on balance, as long as it's accurate, Congress struck the balance that's where it should be. So those kinds of obligations to provide consumers those rights came from the Fair Credit Reporting Act. It doesn't come from the underlying, just interpretation of the FTC Act. So that's one of the kinds of things that rulemaking couldn't do. It's also very unclear whether it would preempt state laws. And also, only the FTC can enforce an FTC rule. So unlike COPPA, which gave the state AGs the authority to also enforce, a federal law would create that, I would hope, would create that ability in the state AGs too.
Well, it'll be interesting to see where we are, a year from now.
Yes.
What is your level of optimism and enthusiasm as we sit here today?
Well, I always try to be an optimistic and enthusiastic person because I feel that there's enough doom and gloom in the world, and why not? Why not be optimistic but realistic about where progress can be made. Look, I see serious engagement in Congress on these issues, and a lot more people backing federal privacy legislation in industry than I'd ever seen previously. So I think a lot of people are coming to the table, as long as they have something that, again, that it's not just a 51st obligation for them, right? That they get a level of like consistency and certainty. I hear from clients sometimes, what is the standard? We'll comply to that standard, but we can't. It's very expensive. It was very expensive to comply with GDPR, very expensive to comply with CCPA. And I think there's this idea that like, well, am I every, iteration now, there's something new. I think there's a real desire to say like, well, let's define and come to sort of a resolution. And then we can all, we can comply with that and have confidence that if we've complied with that, that's what the rule is. Right. I think sort of the uncertainty is also very difficult for companies to say, well, I'm trying to design products that are going to come out a year from now. Is that going to be allowed a year from now in, some state passes a new law? So I think that kind of certainty would really be beneficial too. And that certainty comes from a uniform.
Well, and look, and I think there's maybe some cause for optimism because the support crosses party lines, which is,
yes,
as we know, is a necessary but not sufficient condition to be able to pass legislation. So stay tuned. I think this is a interesting area. Lots more to come, and if the law passes, I think there'll be a lot of interesting work helping clients get ready to comply.
Yes, absolutely.
Let's shift gears. Let me ask you this, Maureen. What advice do you have for a younger lawyer who wants to do what you do?
Some of the best advice I got early in my career was don't hide your light under a bushel. That you need to get out and get your ideas out there and get them associated with you. I think sometimes there's this idea that life is like school, and if you do the best work and you write the best paper and you get the highest grades on the exam, you will get, recognized, you will get moved, forward. But careers work a little bit differently, right? You need to do those things, but you also need to get to know people and get people to associate your abilities with you. So one of the things, really good advice I got early on was to join the antitrust section and to get involved. So I actually started as like a low-level person on the Antitrust Law Journal, and then moved my way up to be like a senior editor. And as you probably know, for that, you have to have, I think, written an article and overseen a symposium. And that was wonderful. That gave me lots of, connections with people, and also then kind of got my ideas out more in the community. So that's always my advice. And
it's not easy for some of us to to do that. It doesn't necessarily come naturally. And I think likewise, it's hard for people to really take credit for the work that they've done. But I agree with you. It's really important because if you don't do that, there aren't a whole lot of people who are going to do that for you.
Nobody's in charge of your career but you. And I think that's right. And also, it's not necessarily comes naturally to people. I'm kind of an introverted person, believe it or not. But I got used to doing a lot of public speaking. And I remember one of my first big things was speaking at the spring meeting many years ago, and feeling very nervous before I did it. But I thought, well, I'll never feel this nervous again. This is the most nervous I will feel. And that was true. And then it's now become really just kind of second nature. But it's like all things. It's through practice that you get that you gain those skills.
Well, well, then let me ask you a different question. Tell us something interesting about yourself that we wouldn't know if we only knew you professionally.
Well, let's see. If you only knew me professionally, you may not know that. So I went to George Mason Law School at night. I started when my oldest child was 3 months old. I had my second child at the end of my second year. I was expecting my third when I graduated, and I had my fourth while I was working on the DC circuit. So I have a very robust, fun family life. I now have 3 grandchildren. Whenever I ran into, frustrations in my career, it was always a real joy to have the family that was, my refuge. I'll put it that way.
You know what? And
It sounds like you're a multitasker on a global scale.
No, it's one day at a time. I'm like, how do you eat an elephant? One bite at a time. How do you do this? One day at a time. One day at a time.
No, that's completely right. But what's interesting, Maureen, is, and I don't want to attempt to date you, but let's say this wasn't last year. I mean, as you were going through law school and working, clerking and doing all those different things, having young moms doing that was much more unusual.
It was very, out of the ordinary. I think the workplace and sort of expectations have changed so much more flexible, but for women and men, which is really nice. So as I see for my kids, as they're having kids, just a much more flexible approach that I think is really, really nice.
All right. Well, that's great. Well, let's go to our final segment, free advice.
Okay, Maureen, here we go. In this segment, we ask the world's leading experts in antitrust and competition and consumer protection law for some free advice about topics having nothing to do with any of their expertise. Today's question comes from AskDogLady.com, written by Monica Collins. This is from her June 13th, 2014 post, and it goes as follows. Listen carefully. Dear Dog Lady, the latest dog walker I employed left my dog behind after an off-leash outing to a nature preserve. Salty was found wandering near a busy road by a Good Samaritan stranger who knew to call me because of the collar with my phone number and Salty's name embroidered on it. That collar and a kind stranger saved Salty's life. The dog walker cried and apologized again and again, and now he wants another chance. I'm tempted to forgive him. What do you say?
I would try to see what the experience of other customers has been. Was this a one-time oversight, or is this a pattern? Because that's a worrying thing that has very sounds like very upsetting for the dog and for the owner. So it doesn't really speak to a certain carefulness in that person, but I don't know. We all have bad days.
I dumped the dog.
Wow,
walker.
you're much nicer than I am. I would forget about it.
I thought they were going to ask if Salty had a cause of action, and whether the dog walker, I don't think that's that close. I mean, Maureen, you're so nice. I don't think it's that close. I think
the quality of mercy, right, is.
Well, it's true that the letter does not supply a lot of information. How did it come to be that the latest dog walker I employed left my dog behind?
Well, what's a dog walker supposed to do?
Happen?
I don't get that. Is that the dog walker is supposed to have the dog on the leash? That's how you walk a dog. And then, you forget the dog. 1, 2, 3, 4.
Well, I
don't understand.
Yes, you were. You're probably right. And I will say, if it was a babysitter and a child, I no second chances.
Yeah, I have a dog. I mean, as listeners to the program, no, I have a dog. He's not very smart, but he probably, if he had been left in the woods, he just would probably hang out there and whine.
Well, it sounds like Maureen is not a hothead, but very prudent and careful thinker. Thank you so much, Maureen.
Thank you.
All right. Thank you, everybody. We will see you next time on Our Curious Amalgam.
Thank you for listening to this week's episode of Our Curious Amalgam, a competition, consumer protection, data protection, and privacy law podcast. It is produced and shared around the globe by ABA's Antitrust Law Section. The opinions expressed by the participants in this podcast are their own and do not necessarily represent their employer or other organizations. If you like what you heard or would like to become a member of the American Bar Association, please check out what the Antitrust section has to offer at ambar.org/antitrust. You can learn more about our podcast at ourcuriousamalgam.com. If you have comments, suggestions, or podcast ideas, please reach out to us at podcast@ourcuriousamalgam.com. Until next time, thank you for listening.